don't believe I knew anything about John Simpkin's concerns. The understanding I had of Steve Parker is he just had a natural reluctance to be a witness. And from those emails, it appears it was because he had a friend or someone he knew had given evidence somewhere else. But I didn't know much more than that.
Were you aware of, for example, any historic issues within Fujitsu which would mean that individuals were reluctant to give evidence? We've heard, for example, in this inquiry about Anne Chambers giving evidence and being unhappy about the situation that she was put in.
Nobody drew my attention to any connection between Steve's concerns and any matters like that.
I want to move on now to the strategy towards the claimants themselves. Could we please turn to poll 406379? This is a document entitled Litigation Strategy Options, produced for the steering group meeting of the 11th of September 2017. Was this a document that you produced?
It was either me or my team.
Could we please turn to the third page? It sets out various litigation strategy options as they then stood. And I'd like you to look at number 5, attrition. It says there, stretch out the litigation process so to increase costs in the hope that the claimants, and more particularly their litigation funder, decide that it is too costly to pursue the litigation and give up. And it says recommendation, this option is not recommended as we believe the pressure on and costs to post office would become unbearable before the claimants give up. And we see on the right hand side the reasons for that. The claimant's litigation funder is an experienced funder with deep pockets. It will be prepared for a long piece of litigation. So long as it believes the merits of the case are favourable, it can be expected to fund the litigation. Over time, the litigation will become more disruptive to post office's business as more operating practices are put under the spotlight and then have to be overseen by lawyers in order to avoid problems in the litigation process. Although media reporting on this matter is presently low-key, there is increasing chatter in the network and feeling that the litigation may start to dissuade individuals from being postmasters. This will increase as the litigation continues without a result in post office's favour. So at that stage, the clear recommendation is not to go for attrition because there are, amongst other things, downsides for the business and also the costs to the post office in pursuing that would be very significant. Is that a fair summary?
Correct, though I would also just note there bullet 2 in column 2, which explains that what this means in practice would be agreeing with the claimant's proposals for case management, and they at that time were advocating a long course for the litigation.
Thank you. You've addressed this in your witness statement. Could we bring up your witness statement, please? And it's page 204. Thank you. So it's page 204. I think you've set it out at paragraphs 357 to 359. I just want to have a look at 357 and 358, if we may. So you say that as for option 5, that's option 5 in the document, the attrition option, as the paper makes clear, this was not a strategy I recommended because the cost to the post office would be too high before the claimants would feel the impact of this approach. Insofar as it is to be suggested that this approach, or indeed any approach which had the effect of applying pressure to the claimants, would have been inappropriate, or that any individual steps the post office took that put pressure on the claimants was inappropriate, I highlight that applying a reasonable degree of pressure to one's opponent and or pursuing strategies which have the effect of applying pressure to one's opponent are part and parcel of an adversarial system of litigation. It was proper to include this so the post office could see the full range of options. However, at no stage did I recommend that the post office adopt this strategy, and at no stage did the post office instruct me to adopt such a strategy. Just pausing there, you say that it's part and parcel of an adversarial system of litigation. For you, does it make any difference whether the party is owned by the government or not?
I saw this as an ordinary piece of commercial litigation.
Thank you. And then 358, more generally, as explained above, where it was consistent with my duties to the court, my client, and my professional obligations for Womble Bond Dickinson to advise on approaches which had the effect of applying pressure on Freeths and the claimant's litigation funder, these approaches would be explained to the Post Office as advantages of a particular step or action. However, at no stage did I advocate taking a step purely for this effect. Where this factor infrequently arose, there was always an overarching meritorious reason for recommending a particular course of action, a byproduct of which may have been to place pressure on the opposing legal team. So you're setting out there that at no point did you recommend that as a strategy. It may be a byproduct of some other strategy. Is that a fair summary of that?
What we're talking about here is what I would call as a pure attrition strategy, where a party takes unreasonable points for the predominant purpose of causing one's opponent to incur costs. I don't believe I ever advised Post Office to take such a strategy. There were times during the litigation where there were meritorious reasons to take a point that had a byproduct of applying pressure onto the claimant.
Thank you. Could we please turn to poll 406380? I think this is another document that you've explained in your witness statement. We're now on the 11th of September 2017. And it says, on the 19th of October 2017, there will be a case management conference. At this court hearing, a judge will decide on the strategic direction of the group litigation. The paper explains the nature of a CMC and the court process that may flow from it, and the general strategic direction that we recommend is adopted by the Post Office. Was this a document that you produced?
I suspect I was the primary author, but it may have had input from others as well.
If we scroll over the page, please, there's a section on overall Post Office strategy. And it's very similar to the strategy that we saw in that email from you yesterday. I'll just read a few sections from it. There are no silver bullets in this case that will dispose of all claims in one go. 4.2, this leads us to the view that in the fullness of time, Post Office may need to address each of the 522 claims individually, given the diversity of the circumstances. Taking each case to a full conclusion through the litigation process is unattractive, as it would take years and the costs would be extremely high. So again, similar, it would cost a lot of money for the Post Office to pursue that kind of a strategy, therefore not recommended.
Not to take the entire case to conclusion, because what I was anticipating is there would probably be a series of thematic trials, followed by eventually having to deal with the details of 500 plus individual claims. And I didn't think that was practically feasible.
4.3, we believe the better solution is to try to force the claimants into a collective position where they will either abandon the claims or seek a reasonable settlement. It should be remembered that the claims are financially supported by Freeths, whose fees are at least partially conditional on winning, a third-party funder and insurers. Without this support, these proceedings would not have been possible. All three entities will likely have the power to pull their support if the merits of the case drop below a certain level. Our target audience is therefore Freeths, the funder and the insurers, who will adopt a cold, logical assessment of whether they will get a payout rather than the claimants who may wish to fight on principle regardless of merit. So that isn't advocating at this point a strategy of attrition, but it is saying that we need to keep an eye on those who are actually funding the litigation.
Yes, and the key point of that sentence is that it refers to the fact that those entities may pull their support if the merits of the case drop below a certain level. So this is advocating a merit-based strategy.
Does something change over time, or is it your position that that was the approach throughout?
I think that was largely the approach throughout. Later in the litigation, and I think this is probably around the time of the trials, I got an impression, but I had no information, that the claimant's legal team were struggling potentially to keep up with the pace. We were also struggling, to be fair. And that became a bigger issue to consider, to factor in. But I think always we were advocating strategies that had merit.
Could we please turn to poll 0031290? So this is a year later now. If we scroll down, 1st of November 2018, and as you say, I think this is probably the document you may have been thinking about. It's thinking about a third trial. It says, this is a long email setting out some initial thoughts on a possible trial in May 2019. I presume that at some point during the Common Issues trial, Fraser will grab one of the free days to talk about this, and so we need a plan. The below represents a straw man for everyone to take shots at. I appreciate that everyone is extremely busy, but we need to put some time aside with the full council team to talk through our proposal for May. I'm going to suggest a conference call for Monday at 10 o'clock. Shout now if you really can't do it. Also, I'm sure that everyone can raise a million reasons why the below is crazy. I think it's crazy, but we need to find a way forward, so we all need a positive, if deluded, mental attitude. If we scroll over to the next page, please. Key dates. So the Common Issue trial finishes on the 6th of December. Horizon Issues trial begins 12th of March onwards, and you're planning for the future. General objectives of a third trial. I can see three potentially conflicting objectives for a third trial. 1, to progress the litigation as a whole towards conclusion. 2, to secure some form of tactical advantage that forces the claimants to quit/settle. 3, to keep Fraser happy by doing something productive in May 2019. Challenges, factors for consideration. I'd like to take you to the 5th one of those. It begins, we should not assume that we have deeper resources than the claimants. We undoubtedly have more bench strength, but every task is much more onerous for us. Our disclosure is at least 10 times larger than the claimants. We will have loads of witnesses, they will have a few, etc. And then you say, that said, my instinct is that the claimants' funding is under pressure and they do not want to be burning money on a third trial. Is this the turning point that you were referring to just now?
I wouldn't describe it as a turning point. It was just an impression that we began to have, or I began to have, around that time.
If we please turn to page 5, there is the straw man that you are setting up for others to comment on. And you say as follows, during the attached together, I think we need a plan that can be flexed to accommodate the possibility of an appeal. Also, tactically, the best options for the post office are 1, to force the claimants to burn money, and 2, to target limitation. My straw man, therefore, tries to achieve these objectives whilst trying not to look tactical. And then you say, for example, we agree to a lead cases trial of 3 cases, etc. Now, the witness statement that I took you to before said that you never advised that as a strategy. Here we have, it seems, you're advising that at this point in time as a strategy to force the claimants to burn money. Do you agree with that?
I don't agree with that. This is a straw man discussion amongst the lawyers with the council team. I think I did forward it to Roderick Williams, but it's expressly under cover of an email that says this isn't advice. It's just, I think I used the phrase brain dump of ideas. These points were discussed. Even here, though, the strategy is to target limitation, and if you scroll slightly up in this email, you can see I set out the advantages of targeting a limitation issue, so there was reasonable merit. And in any event, what happened in practice was that the trial date moved back and this discussion never went anywhere. So I don't believe this ever ended up as actually being advice to the client, as opposed to a point being discussed amongst the lawyers.
What is the difference between a brain dump to a client by a solicitor and advice from a solicitor?
I think Roderick Williams would have understood this as an experienced in-house litigator, that this was just some ideas that were being knocked around amongst the legal team, and it wasn't a settled view on the way that Post Office should have proceeded.
But it was your view as to how they could proceed?
It was one option. I think if you scroll through the entire email, it sets out a whole range of different options, and as it sets out at the start, it's a starter for 10 for discussion amongst the legal team.
Could we turn, please, to the judgment in the Common Issues trial? That's at UKGI 409458. And it's page 172. You're about halfway down that paragraph that's on the top of the page. So if we scroll up slightly. Mr. Justice Fraser says as follows: the Post Office has appeared determined to make this litigation and therefore resolution of this intractable dispute as difficult and as expensive as it can. Does that not reflect the advice that you were giving to Post Office in 2018?
As I say, I don't accept that that was the advice that was given to Post Office. It was an idea being discussed amongst the lawyers, and ultimately it never came to fruition because the trial date moved back and matters moved on. I don't think actually decisions around trial 3 were made for several months after that point.
I'm going to move on to another topic now, and that's the Post Office's relationship with government and UKGI. That can come down, thank you. Roderick Williams has given evidence to this inquiry describing a meeting in the middle of 2016 with the Department for Business, and I think he said that you were present at that meeting, where the department was asked by the Post Office to be able to conduct the litigation without external influence. Is that a meeting you have any recollection of?
I'm afraid I have no recollection of that.
Do you think it's likely that you attended a meeting with the Department for Business in mid-2016?
I don't recall any meetings with the Department of Business. I recall
UKGI?
Sorry, or UKGI. I recall briefing one of the board directors who had been appointed by UKGI, and I think there were some UKGI attendees at that meeting.
Was that Tom Cooper?
It was Tom Cooper.
Let's turn to that then. Can we please turn to WBON 40528, please? This is in 2018, so 2 years after that apparent meeting. Now, this is an email from Amy Prime to yourself, subject notes from call with the Post Office on the 23rd of March 2018. Can you assist us? Is this Amy Prime sending you notes that she took while you were having this discussion?
Give me a moment to read, please.
We can scroll down if you like. Perhaps I'll take you through some paragraphs, and then at the end you can tell me how you think this was formulated.
Thank you.
She says, Andy, note from the beginning of the call below, Bayes and UKGI are taking a more proactive approach. 2 issues with this. 1, the relation to piece of litigation they got stung, so worried about no surprises in Post Office litigation. And 2, wish to protect public money and value for money, so being quite intrusive. A bill of £110 million in compensation to supplier a nuclear procurement deal, which has caused more intrusive oversight. It then refers down there to Tom Cooper. So Tom Cooper was the from UKGI. He sat on the board of the Post Office as well? Is that right?
Yeah, he was on the board of directors at Post Office, and as I understood it, UKGI had the power to appoint a director to the board.
It says, question whether we are tying him down to an information sharing structure and signing a non-disclosure agreement, question mark. Not NDA, director of company, so has confidentiality undertakings already. Appointment letter has made issues with confidentiality. UKGI want Tom to tell UKGI what he wants to and not be constrained in his ability to share information. So it looks as though there is a concern being expressed at this meeting about the ability for Tom Cooper, who sat on the Post Office board, to share information with UKGI. Is that your recollection of the discussion?
It's not my recollection because I'm not sure that I was on this call or not, but that appears to be what the words are saying there.
Do you recall an issue at this point in time arising from UKGI wanting to know more about the litigation and perhaps the Post Office pushing back on that information sharing?
I was aware that there was an issue with information sharing with UKGI, particularly around sharing privileged information with UKGI and how to do it in a way that would maintain privilege.
And was that a concern that you personally had?
I would always be concerned about issues around privilege and making sure the Post Office were properly advised on those issues.
Having read just those couple of paragraphs, are you able to assist us any further with how this note might have come about?
I'm afraid not. I don't recall this note, and I don't recall the call that it appears to be referring to.
After CCRC material, deeply suspicious about ability of UKGI to control flow of information. Is that something that you're able to assist us with?
I'm afraid not.
It looks as though there was a concern that UKGI had shared some information relating to the Criminal Cases Review Commission. Is that something you recall anything about?
I don't recall that.
If we scroll down slightly more, we'll give board update on progress of litigation as per Womble Bond Dickinson, speaking notes, discuss protocol for engaging with UKGI and concerns with appointment of Tom Cooper. Do you recall at this period a wish for Mr. Cooper to stick to notes that were prepared by Womble Bond Dickinson to update UKGI rather than, for example, being able to speak freely?
I don't recall that issue being raised with me.
If we scroll down, please, over the page to near the bottom of that page, it says Alex Chisholm is accounting officer for Post Office and accountable for spend in the Post Office to ministers. And it says at the bottom, subcommittee papers to be kept to a minimum and updates from committee to board to be verbal. Tom Cooper will be updating UKGI, which causes issues with directors' duties. It might be suggested that that is quite consistent with some of the advice that we saw from you yesterday, keeping papers to a minimum, updates to the board to be verbal. Is that advice that you gave in relation to UKGI at this time?
I don't believe I was deeply involved in these discussions. The arrangements between Post Office, its board, and UKGI were mainly handled in-house by the Post Office legal team. I recall there was a concern not about providing written updates, but just the sheer volume of written updates that were being requested and the capacity and practicality of providing them.
The suggestion here, though, seems to be to use the language that we were speaking about yesterday, updating on a verbal basis rather than a written basis. As you say, you've expressed concerns about privilege. Mm-hmm. Do you recall those kinds of concerns in relation to UKGI?
I recall that Post Office had concerns about if they provided information to UKGI, where else would it then go after that? Other than that high level, I don't recall what the detail was or what caused Post Office to have those concerns.
The final document on that topic, could we please turn to poll 30417770? And if we start on page 2, please. The second half of page 2, I think you've addressed this in your witness statement to paragraph 433. We don't need to turn to the witness statement, but if we could just have a look at this email from Elizabeth O'Neill at UKGI to Roderick Williams. It's about agreeing a protocol with UKGI, I think, for information sharing. She says, thanks for your markup of the protocol. It looks as though we're still a long way apart on this, as your draft doesn't recognise a number of things that are essential to us in order to fulfil our function as shareholder and representative of the Secretary of State. So I thought it would be helpful to provide some important background and explain the context in which we are operating. Alex Chisholm is the accounting officer for the Post Office and as such is accountable to Parliament for its actions. In order to properly fulfil this role, he requires full and comprehensive information on the progress of this litigation. This will not be possible if the Post Office is not willing to provide written updates. We revised our requirements to provide for updates following reports to the board to reduce any administrative burden as far as possible, but we cannot agree to a protocol which includes no obligation on the Post Office to report progress in writing in the litigation. So UKGI seem to have the impression at this stage that the Post Office don't want to report in writing relating to the litigation. If we scroll up to the email above from Jane McLeod, she says, Andy Rod, I'm very concerned about this and I'm struggling to see a way through this. Paula has offered a meeting with Alex Chisholm to explain the issues and that may be the only way to get around this. And asks for thoughts. If we scroll up to the first page, you're not actually, you're included in this email chain, but I don't think you have any comments to make on this chain. If we scroll down, please, we see at the bottom email, Patrick Bork, 11th of May, it says, I've just come off the phone to Richard Callard when this came up. Andy, Rod, shall we get on a call? Do you remember any call in May 2018 relating to this issue?
I think I did have a call, but I can't remember the details of it.
Looking at this, and just from your general reflections, to what extent do you consider the government and UKGI, so far as you were aware, were properly cited on the progress of the litigation?
That's difficult for me to comment on because I had limited visibility as to what information was moving from Post Office to UKGI. That was mainly handled by the Post Office in-house.
And from those who we saw copied in or sending those emails, did they ever give you any impressions about the desire to which they wanted to share or not share information with UKGI?
Yeah, there were concerns expressed by, I think, mainly Jane McLeod and Roderick Williams about sharing privileged information with UKGI. That's not because they didn't want to give it to UKGI, they just wanted to make sure it was being provided in a way that maintained privilege and confidentiality around that information. But beyond that, that was the only impression I had.
And did you provide advice in that respect?
I provided some advice around how they might mark up the protocol to cover privilege issues.
Thank you. I'm going to move on to my penultimate topic, certain advice given by Brian Altman. Could we start with poll 003333855, please? And these are notes of a conference on the 9th of September 2013. First of all, if we scroll down slightly so you can see some of the handwritten markings, are you able to assist us with whose handwriting that is?
It's not mine, but I couldn't tell you whose it was otherwise.
Are you able to assist us with how these kinds of minutes would be agreed?
Because this was with Brian, the minutes would have been prepared by Gavin Matthews. So I don't know what process he followed. I don't recall. Though I think specifically on this minute, I remember. I think this went to Brian for approval. I think.
Brian Altman.
Brian Altman.
Thank you. If we please could turn over the page to the bottom of the second page, we can see there in this draft version, the penultimate paragraph, please. It says, in relation to the cut-off date, 1st of January 2010, was close to the Horizon Online rollout. Prior to the Horizon Online rollout, there was a cash audit done so that all post office branches balanced. If we turn to page 4, we can see these are an updated version of the minutes. And if we turn to page 6, we can see the same paragraph there. It's slightly changed, so it now says, in relation to the cut-off date, 1st of January 2010 was close to the Horizon Online rollout. Prior to the Horizon Online rollout, there was a cash audit done so that all post office branches balanced. Brian Altman advised that there was no positive duty to seek out individuals pre-1st of January 2010, but if the post office was approached, it would need to make case-specific decisions on disclosure. So it has that extra sentence added there. If we could also please turn to page 3 of this document. We can see there in this first version, there's another section on Mr. Altman's advice. Brian Altman advised considerable caution in relation to mediation cases involving previously convicted individuals. Seema Misra had already indicated an intention to be within the scheme. The concern is that the lawyers acting for these individuals may be using the scheme to obtain information which they would not, and somebody's put in the word normally, be entitled to in order to pursue an appeal. And if we turn to page 6, the updated version, we see there that the word and the minutes updated. Could we please have on screen side by side the current document and also poll 00333-856. We start on the first page on both, please. Now on the 856 version, there is also handwriting. If we could scroll down. If we keep on scrolling over the page, you can see some more handwriting. Are you able to assist us at all with that handwriting?
No, other than to say it's not mine.
And you can see that, if we put that side by side with 855, but we look at page 2 of 855, sorry, actually, if we go down the page on the left-hand side to the bottom of the page, thank you very much. That's the in relation to the cut-off date section. And on the right-hand side, if we look at the bottom of page 2, please. We can see that wasn't in the original and has been added in. And we saw the further final version, which had those handwritten notes added. We can see the same if you go to page 3 on the left-hand side. And 3 on the right-hand side. So the right-hand side had normally added. That's now in place on the left-hand side. It looks as though quite a lot of care has been taken over the minutes. Is that your understanding of the practice of your firm around this time taking these kinds of minutes?
I don't recall that I was involved in the preparation of these minutes, so I couldn't comment as to... I suspect they were prepared by Gavin, and I can't comment as to what approach he took.
The section there on Brian Altman advising considerable caution, is that something that you recall from the meeting?
I don't recall it specifically from the meeting, but the general tenor of that advice I recall around that time.
Advice coming from Mr. Altman himself?
From Mr. Altman and also Cartwright King.
Could we please move on to poll 001-39866? This is Simon Clark's own note of that particular meeting. Martin Smith's note of that meeting. Thank you very much. If we scroll over the page, please, we can see a section there, halfway down. It says, Simon, we discussed last Friday, main problem is cultural, people in different departments, needs to be a proper coming together. Rod, a lot of issues, not important, e.g., turn computer off and then on again, and then things which may affect continuity still need a steer. Simon, we said we would write a protocol, roles and responsibilities, etc., centrally archived, owners of issues. And then it says this, QC refers to a couple of non-identified individuals, in brackets, referring to Simon Clark's advice on disclosure and duty to retain. And then Simon says, think Post Office have resolved those issues. If we move on to the actual notes that we've just been looking at, could we look at poll 3021998? And the bottom of the first page, the note says, Roderick Williams, RW, then confirmed that the weekly hub meetings were starting to bed in, picking up any issues across the business which may relate to Horizon. Simon Clark said there had been some cultural issues at the start, which had now been overcome, but he thought that it was necessary to put duties on individuals, etc. There's no mention there of the Simon Clark advice on the duty to retain, the shredding advice as we know it. Can you assist us with why that might be?
I wasn't the author of these minutes, so unfortunately I can't.
Do you recall at that meeting that issue being discussed?
I don't recall the meeting.
You don't recall the meeting at all?
I recall there was a meeting. I don't recall the content of the meeting.
Final topic. Thank you very much. Scotland, Northern Ireland. What was your understanding of the Post Office's legal advisory arrangements for the devolved nations?
In all regards, do you mean?
Yes. Did you have any particular understanding about their actions in Scotland, Northern Ireland, or any involvement in those?
From a civil side, I believe they operated the same way as they did in England. On a criminal side, I understood that they couldn't bring private prosecutions in Scotland. I can't remember what the position was in Northern Ireland.
Did any cases from Scotland or Northern Ireland fall within the remit of the things that you were advising on?
Yes, because there were cases from Scotland and Northern Ireland within the group litigation.
And outside of the group litigation?
There may have been some in the mediation scheme as well, but I now can't recall.
Did you have any involvement with Scottish firms instructed by the Post Office at any stage?
I can't recall any, but I may have done, but I can't recall.
And how about the Scottish CCRC?
I don't recall any.
Okay, thank you very much, sir. Those are all of my questions.
Right. Now, is it still the case that we have 3 would-be questioners?
That's correct, yes.
and that one is, well, have they agreed an order between them? Should we put it in that way first?
I believe they have, although I think they would appreciate our first morning break now, if possible, before we begin.
Yeah, I've got no problem with that. And given the timescales that you've mentioned to me for questioning, we can take 15 minutes, can we not?
Absolutely.
So we'll resume at
Quarter to
11.
So, for the benefit of others, can I indicate that during the course of the morning, Mr. Blake has dealt with the document that I intended to focus on with Mr. Parsons. So I now am able to say that the inquiry will not be burdened with questions from me.
Well, it's never a burden, Mr. Maloney, but thank you for letting me know.
So in that case, it will be Mr. Steen, followed by Mr. Henry.
Right.
Mr. Jacobs, followed by
Mr. Jacobs, fine. So, and that's the order. And just so that we can plan it properly, Mr. Jacobs is of the order of half an hour, yeah?
I think so. I'll hope to be shorter, but yes, about half an hour, sir.
Right, that's fine. And Mr. Henry, an hour. So I think we will. Sorry, Mr. Henry.
No, I do apologise. So I didn't mean to cut across you. I just wanted to see if it might be possible that I could take an hour and 10.
All right. I don't think there's any problem with that. It's just ensuring that the stenographer has an appropriate break as between Mr. Jacobs and you. And can I ask you, Mr. Henry, do you want to do your hour and 10 in one go, preferably? Or would you be happy to have a break in the middle of it?
I'd be very happy to have a break in the middle of it if that is what you and the shorthand writer would like, sir.
Right. Well, we'll see how we go, and I'll bear all those things in mind. So we'll have our first break now, and since I've been talking in the 15 minutes, we'll start at 10 to 11, Mr. Blake.
Thank you, sir. Just to add, Ms. Dobbin has a few questions as well.
Oh, well, if we're talking about minutes, then that's no problem.
Thank you very much.
Are we ready? Yes. I can see Mr. Jacobs preparing his microphone.
Thank you, sir. Can you hear me, sir?
Yes, I can. Thank you very much.
Mr. Parsons, good morning. I ask questions on behalf of 156 sub-postmasters who are core participants in this inquiry and are represented by Howe & Co. Some of our clients attended the inquiry yesterday and are here today, and many, many others are watching remotely through the live feed. And the view that they've expressed, and I think you were asked a question yesterday on the same point, is that you became too close to your client. And we saw yesterday, after the Panorama programme in 2015, you asked a question of your client whether the Post Office could start attacking the postmaster's credibility, calling people out as the liars and criminals that they are. Your words. Page 111 of the transcript from yesterday. Mr. Parsons, you had a client which was behaving badly, but instead of taking a step back, you joined in with what they were doing. You were joined in and helped them, essentially, throwing sub-postmasters under the bus. Now, my question for you is, having been taken to the documents that Mr. Blake took you to yesterday and today, are you now able to accept that that is what you did?
Back at the time, I accept that some of the language I used was too strong. I look back on some of the decisions that we made and think now we could have made different decisions. And as I say in my statement, I apologise for the mistakes my firm made along the way. But if we're talking back at the beginning of the process, at that time, I understood Post Office to have a fairly arguable case, that Horizon worked. And as a result of that, and being their lawyer, I'm required to advance that case on their behalf.
Okay. Mr. Parsons, did you conspire with your client to downplay important matters so as to keep sub-postmasters in the dark about the very issues which have given rise to this public scandal?
I never conspired with my client in that regard. We would consider each matter as it came up. Some issues we thought were more important than others. Some issues we would emphasise more than others. And some issues which we considered irrelevant, we would de-emphasise.
Well, on the topic then of conspiring to downplay important matters, can we look at POL 000129392? And it's page 2 of 3 if we could scroll down. Mr. Parsons, while we're waiting for that to come up on our screens, it's an email dated the 17th of June 2014, which you sent to Chris Ojard, John L. Singh, Angela Vanden Bogard, Belinda Crow, and others. We'll just wait for it to emerge. Thank you. If we could go down to page 2. And further down, please. Further down this. So it's this email here. So it's from you. And you say, I've just spoken with Cartwright King about a new CQR from Howe & Co. that references the Helen Rose report. And then you talk about the Rose report being retrospectively disclosed in a number of prosecution cases, drawing into question statements made by Gareth Jenkins, and a copy of the reports made its way to Howe & Co. And then the paragraph I want to highlight is the paragraph that begins the point of concern, third paragraph. The point of concern is that the M060 CQR is starting to make the link between, one, the fact that the Helen Rose report makes it clear that Gareth Jenkins knew of issues with Horizon, and two, the fact that Gareth Jenkins never mentioned these issues in his prosecution evidence. See paragraph 53, we don't have the CQR to hand. And then you say, this line of inquiry draws into question the credibility of Gareth Jenkins' evidence. And then you make a criticism or a potential criticism of Howe & Co. And you say the sharing of the Helen Rose report between applicants is potentially a breach of ethics, contempt of court. However, Cartwright King and I don't believe attacking the solicitors on this point will be of benefit. If anything, it may draw more attention to the Helen Rose report. And then scrolling down again, your advice that you give to your client is, instead, our preferred approach is to downplay the importance of the Helen Rose report in any post office investigation reports. We recommend minimising or ignoring entirely the Helen Rose report when responding to CQRs. And my question for you, Mr. Parsons, is, looking at this document, this clearly shows, doesn't it, that you were concerned that Howe & Co. were on the brink of discovering that Post Office's expert in horizon-based prosecutions had not been credible. That's what you were downplaying or advising to downplay, isn't it?
I think it's important to understand that the Helen Rose report contains two separate pieces of information within the same document. One is the Gareth Jenkins issue, which was being addressed by the criminal lawyers, Cartwright King, and they had made a decision, 9 months before this, to disclose the Helen Rose report without telling sub-postmasters about the Gareth Jenkins connection. The second issue in the Helen Rose report is about the reversal of transactions, which was the subject of spot review number 1. Now, from my perspective of advising on the scheme, where prosecution issues weren't being considered, the relevant part of that report was the auto-reversal of transactions in spot review 1. So that's my primary viewpoint on it. However, reading this again now, it seems to me that there was a greater underlying problem here, which was the original disclosures by the criminal lawyers and not drawing out the Gareth Jenkins connection.
But it's you, isn't it, giving the advice to downplay the importance of the Helen Rose report, not Cartwright King. You're advising Post Office to minimise and ignore and downplay the report because you were concerned that Howe & Co. were joining the dots together and would find out about Gareth Jenkins. This is what the email says, isn't it?
That was one of the concerns, but I would just note, if you scroll up slightly in the email, I believe it says I've just spoken to Cartwright King.
Yeah.
And when it says our approach, that is clearly referencing the joint approach of both the criminal lawyers and the civil lawyers.
The Helen Rose report was a Pandora's box, effectively, for solicitors acting for sub-postmasters, because it would enable them to challenge the Post Office and say, on the reversals and the remote access points, well, you need to prove that the figures that you are accusing us of inputting actually came from the sub-postmaster and not from the system or from Fujitsu. That would have been an enormously important thing for Howe & Co. and other lawyers representing people to have known about. That's right, isn't it?
So, as I understood it, Howe & Co. had the Helen Rose report. The only information that had been redacted from it was personal data. Those redactions were applied by the criminal lawyers. So I believe the rest of the issues in the report were there to be read.
But not Gareth Jenkins.
No, correct. Gareth Jenkins' names have been redacted by the criminal lawyers.
Well, you confirmed yesterday, didn't you, in questions put to you by Mr. Blake, that you advised that Gareth Jenkins' name should stay redacted.
As I said yesterday, I was passing on the advice of the criminal lawyers.
Let's have a look, shall we, going further up the email chain. So we need to scroll back up again, please. This is Jarnail Singh's response to the email that I've read out. And he says, Andy, I am happy with the proposed approach and it's sensible in the circumstances. And he talks about issues being dealt with on a case-by-case basis. And my question for you is, what circumstances was Jarnail Singh talking about? Wasn't he referring to, don't you think he was referring to evidence having come to light which would cast doubt on Post Office's assertion that Horizon was robust? Those were the circumstances. He knew, and Post Office knew, that their robust mantra could no longer be maintained.
I don't know what circumstances Jarnail Singh was referring to there.
Well, isn't the inference that when he says, I'm happy to take your advice and it's sensible in the circumstances, that you would know, or there would be an understanding between you as to what the circumstances were?
I'm reading that now, and I can't tell you what Jarnell Singh had in mind at that point.
You had read the Simon Clarke advice, I think about nearly a year earlier. Do you think he was referring to that because you're referring to Gareth Jenkins' credibility in the email?
He could quite possibly, especially given that he was a criminal lawyer at Post Office.
So essentially what you were doing for your client was covering up the subject matter of the Clarke advice, weren't you?
I don't think that's a fair characterisation of it. I think there is a question to be asked about the original decision back in, I guess, mid-2013, following the Clarke advice and the disclosure of the Helen Rose report by the criminal lawyers, as to why they redacted Gareth Jenkins' name and why they didn't call out at that point the connection. At this stage, I'm looking to pass on the advice from the criminal lawyers, which is their decision. They've made those choices. I'm not a criminal lawyer. And I'm looking at it also from the perspective of the scheme. As I say, from a scheme perspective, it's a different question.
I don't want to repeat myself, Mr. Parsons, but this is you advising your client. This isn't a Cartwright King letter, it's your letter, isn't it?
It is, but I think it's clear from the email sent below that I'd spoken to Cartwright King. It reflected a combined approach, and they're all copied on the email.
We're now in 2024. It's right, isn't it, Mr. Parsons, that if you hadn't advised Post Office to downplay, minimise or ignore the Gareth Jenkins issue in June 2014, the last 10 years of the lives of hundreds of sub-postmasters who've been convicted, bankrupted, lost their reputations would have been very different. Do you see that?
I do see that, but as I say, I think that goes back to the original problem back in 2013 and the decisions Post Office made around their criminal disclosures at that point in time.
I want to move on to another topic, which is the conduct of the mediation scheme. I'm just going to I'm going to refer you to a couple of statements you've made in your witness statement. We don't need to turn them up. Paragraph 149.2 of your statement, you say, if a case went to mediation, a lawyer from WBD would attend in person to represent Poll. I recall attending 2 or 3 mediations personally, but generally this was done by members of the WBD team who I supervised. That's right, isn't it?
Sorry, could you give me the reference again? It hasn't come up.
Yes, it's paragraph 149.2.
I think, Mr. Parsons, Mr. Jacobs was hoping to do this without getting it up on the screen, but you want it on the screen so that you can see it.
I've got a hard copy.
You have a hard copy.
Got a hard copy, all right.
That might save time. So you've got that, haven't you?
Yes.
And then if we get, I'll just read out paragraph 253.3 of your statement. That might involve a bit of rapid page turning on your part. I'll read it out while you're doing that. You say, I was not of the view that Poll were refusing to engage properly in the mediation process. Now, my question to you is, you must have been aware, Mr. Parsons, that in practice, the Post Office approach to mediations was disingenuous and amounted to a sham. Post Office were not mediating in good faith, were they?
I don't accept that.
Okay. Well, I'll develop my questions to you. Because we've spoken to many of our clients, and let me tell you what one of our clients, Peter Holloway, has told us what happened to him. He says he spent a lot of work preparing for the mediation, turned up, presented what he wanted to say, produced lots of documents in support of his arguments, and then everybody went away. And the mediator came back to see him at about 3 o'clock in the afternoon, looking tired. Mr. Holloway says haggard, and the mediator apologised to him, and he said Post Office are refusing to make any offer. He couldn't quite believe it. He said that the Post Office representatives had been sent to the mediation with express instructions not to settle at all. And this isn't just Mr. Holloway telling us this. We've spoken to at least a dozen other clients who attended mediations, and they all say that Post Office sent representatives, Bond Dickinson were there, to mediations with no authority or instructions to settle. That's what was going on, isn't it?
So each case was assessed on its own merits. Some of those cases we advised Post Office to settle, some of them we advised Post Office not to settle. There was then a discussion internally about whether Post Office should still attend mediations where it had no mandate to settle. And the view taken was that it was appropriate still to attend those mediations so that the issues between the parties could be discussed. I can understand why that would have been frustrating for some of your clients, but it was a decision taken in good faith at the time.
Well, there were offers made in some cases, but our instructions from our clients are the offers were always derisory, and we've heard Paula Venables talk about token offers, and they were made on the basis that the sub-postmaster agreed not to bring any action in the future against the Post Office. So essentially, what Post Office were doing in the few cases where they made offers which were derisory was they were using the mediations to strengthen the position of Post Office against future claims, weren't they?
I think it's fairly ordinary for two parties at a mediation who reach an arrangement to enter into a settlement agreement of future claims.
But making very derisory offers that didn't represent the sort of claims that were made in the group litigation.
I think two parties to a mediation will always have different views as to the value of offers put. As I said, Post Office went into those mediations in good faith, having considered every case. That was my understanding.
Well, it's not good faith, is it, Mr. Parsons, to send representatives into mediation with instructions to make no offer and not to settle?
Well, I hope I explained that just a minute ago, that the intention, I accept that some mediations were conducted on the basis that there was no mandate to settle, but the intention was to go and hopefully explain Post Office's position, and it was thought there was still value in having that conversation.
Can I put to you an explanation of Post Office's position in the mediations that has already been received and evidenced by the inquiry? And it comes from Alan Bates, and in his witness statement at paragraph 157, and we don't need to put it up on the screen, but the reference is WITN 000500100. What Mr. Bates says is, I believe the mediation scheme failed as it was part of a cover-up by Poll. I expect Poll discovered things they did not like and did not want to come out. There was definitely an element of not wanting to accept fault. I believe Poll had no intention whatsoever of getting to a mutually acceptable and fair decision. If anything, it seemed as if Poll had been using the scheme as a fishing expedition to see what evidence sub-postmasters actually had about Horizon. And my question for you, Mr. Parsons, is that Alan Bates is right, isn't he? You supervised this, you were using the mediation scheme in an adversarial way in order to obtain some sort of tactical advantage against the sub-postmasters.
I don't recognise that description of the mediation scheme. My understanding is Post Office went into it in good faith with an intention to reinvestigate the 150 cases, and where those cases showed errors on Post Office's part, it was willing to settle.
My final questions for you. In your witness statement, you haven't made any apology or statement of regret for your actions. And many of our clients have been aghast at the content of the evidence that you've given, the emails that Mr. Blake took you to yesterday. Sally Stringer is one of our clients, and she emailed Mr. Enright, who sits next to me, at 10:20 this morning. And what she says is, of you and your evidence, his evidence is the absolute epitome of arrogance, deceit, corporate corruption, and is an absolute disgrace. I suppose you might think that's quite strong language, Mr. Parsons.
I have apologised within my statement, and to make it clear, I'll apologise again now. During my time acting for Post Office, we made some mistakes along the way. I apologised for them at the time, and I apologise to your clients for them now.
Do you have anything to say for the suffering that Post Office advised, and your advice to Post Office caused to clients of ours, such as, for example, Ms. Stringer and Mr. Holloway?
Unfortunately, I don't know them personally. I recognise the suffering of some of the sub-postmasters, and to the extent that mistakes I made contributed to that, I apologise.
I just need to find out if I have any more questions to ask. I may not, but Mr. Steen and Mr. Enright will tell me. Thank you. I haven't any more questions for you. Thank you.
Thank you. Mr. Henry, can I invite you to take a break in your questioning at some point which is convenient to your line of questioning, but which will give the stenographer a bit of a breather?
Of course, sir. Mr. Parsons, on the contrary, I'm going to suggest that you didn't make any mistakes at all, and that what you did, I mean, there were errors of judgment, obviously. There were very serious departures from standards that ought to have applied, but that what you did was deliberate, it was clear-sighted, it was ruthless.
Sorry, you asking me to comment on that? Yeah. I'm a lawyer acting for Post Office. As a lawyer, it's my responsibility to defend their interests. For a large part of my engagement by Post Office, my instructions were that they considered the Horizon system to be a reliable system, and therefore I defended it along those lines.
And that was the mantra, that was the creed. But you could see that that fundamentalist approach, you must have seen that that fundamentalist approach had yawning gaps in it. But you didn't confront your client about that, did you?
I don't think it's fair to characterise it that way. I think from the start, back when I began, which was mid-2013, the group that I was working with had in their mind that there could be another version of events out there. They believed Horizon was a reliable system, but they were open to the possibility of it not being.
They were open to the possibility?
They were open to the possibility of it, and that is why they decided, in my view, to open up a mediation scheme to allow sub-postmasters to raise those issues.
You know perfectly well why the mediation scheme was set up. You must have gathered that it was Paula Vennell's idea. We've been lumbered with this liability by the Royal Mail Group. Let's try and tie it all up and get rid of it as cheaply as possible and avert the risk of a class action. That's the whole point. It was grudging, it was insincere, it was cynical.
No, I think it's fair to say that Post Office believed the Horizon system worked, and therefore they believed they were in the right position. But at the same time, the mediation scheme was set up, as much as I could see, with a genuine attempt to understand the complaints of the sub-postmasters and, if possible, resolve them.
Well, then why did you say, and there's no need to go to the email because it's already been canvassed by counsel to the inquiry, why did you say that you didn't think that there was any prospect of settling any of the cases through the mediation?
Well, as I explained yesterday, that email was sent before the scheme was fully developed, and there was an investigation phase built into it. And my expectation at the point at which they built the investigation phase in is that may give rise to new information which may cause Post Office to settle some cases. However, I accept there was a large delta between the parties, and that makes it difficult to settle.
But you say it was a view expressed before it was fully set up and worked out. But when you look at the history of the mediation scheme, it was a complete sham, wasn't it?
I don't accept that. For the
It ended in utter failure, didn't it?
I don't believe so. I think it did a lot of good work investigating 150 cases, and I don't have the statistics before me, but in a good number of cases, settlements were reached.
I want to go back now to, very briefly, to the 9th of September 2013. And just help us, please. I don't quite understand your evidence. What are your memories of that consultation that took place at 2 Bedford Row?
I recall there was a consultation. I can recall being in 2 Bedford Road chambers in the room, but I can't really recall any of the details of what was discussed.
Or is it that you don't want to, Mr. Parsons?
I'm afraid it was a long time ago, and I just can't recall the details.
A long time ago, of course, but let's not forget the context. I mean, you were involved in arranging that consultation together with Mr. Matthews, weren't you?
Primarily it was Mr. Matthews, but I accept that.
Yeah. And it was a very, very serious problem that you had, because you had the coalescing of the Second Sight interim review and then the revelation, of course, of Gareth Jenkins and the Clark advice. You were made aware of the problems with Gareth Jenkins, you say, from about the 8th of July, and you read the Clark advice on the 17th of July. Correct?
Correct.
Right. So there must have been quite a lot of expectation and anticipation. I mean, how is the great man, Mr. Altman, going to get us out of this mess? You must have been thinking like that. I mean, you did want to advance in your profession, didn't you?
As I've said before, I wasn't advising on the criminal side, but it's fair to say I was interested to understand what Brian's advice was going to be.
I'm sure you were interested. And why were you interested?
Because it was a serious issue.
Yes, and that serious issue would have impacted with the civil cases that you were trying to keep at bay.
I didn't see it that way at the time.
You didn't?
Though I recognise there is a crossover between sub-postmasters who have been criminally convicted and the civil claims they might then subsequently bring.
Are you really saying to the chairman of this inquiry that you didn't see it that way at the time?
It wasn't the way I was thinking about matters.
Well, we'll come to that, but let's just concentrate on who was there. Can I take it that you were the most junior person in the room?
Yes.
Now, Mr. Jarnal Singh was there, and I don't think he's going to be taking many notes. Then there was Susan Crichton. She was general counsel, rather too senior, perhaps. There was Roderick Williams. Was he scribbling?
My general recollection of Rod is he was someone who made notes. I can't recall if he was in that meeting.
And you would recognise his handwriting?
Maybe.
Maybe. Mr. Clark was there, Mr. Bowyer was there, Mr. Smith was there. We know that Mr. Smith was writing notes and then he typed them up. Your partner was there, Mr. Matthews. You, however, were the senior associate. You would have been the deputed note taker, wouldn't you?
I don't recall being asked to take notes in that conference. I haven't been able to locate any of my own notes from that conference.
How, you haven't?
We've had a look.
What a shame. I wonder where they went to.
Well,
Mr.
hang
Parsons.
on. He hasn't accepted that he made notes, Mr. Henry.
You've looked for you say you've looked.
We've tried to locate my old notebooks.
So would you have been doing it onto a computer or would you have been actually writing it out?
I suspect back at that time I would have taken notes on paper.
Right. I mean, it's not an invariable practice, but often the most junior person in the room, the senior associate in your case, would be the note taker, because they're the least involved in the discussions and they are more or less observing events, and so therefore they are there to take an assiduous note. Are you saying that you have no recollection of note-taking?
I have no recollection of taking notes in that meeting.
Right. I mean, obviously you would have wanted to have been diligent and you would have wanted to have impressed, wouldn't you?
Well, that time, it impressed who?
Well, your partner and the other people in the room. I mean, you were a senior associate. Presumably you had designs on partnership.
Well, at that time, Gavin Matthews was the partner in the room. I knew him well, and as I explained, he was leading on that line of work.
Right. Well, I want to come, please, to those notes because I'm going to suggest that the ones that were preserved by your firm were sanitised. You've already been taken to the point that there is no mention of shredding. Do you have no recollection of shredding being mentioned?
No.
There's no mention of other Misras crawling out of the woodwork. Do you remember an expression of that kind being used by leading counsel?
I don't recall that.
No. It's a rather unfortunate expression, isn't it?
I don't really have a view on it.
You surely, I mean, are you saying that you have no recollection of that?
I have no recollection of it.
No mention of a direct question posed by your partner, Gavin Matthews, should we apologise to Seema Misra, and leading counsel saying, I wouldn't.
I don't recall that.
And curiously at all, no mention at all whether in the circumstances there should be prompt disclosure to Mrs. Misra of the discreditable conduct and breach of court duties of Gareth Jenkins.
If that's what the minute says, that's what the minute says, but I don't recall those discussions.
No, I'm saying that there is no mention of it at all. And in a case, surely, Mr. Parsons, in a case where the Post Office has relied upon Mr. Jenkins as to the efficacy of the Horizon system, they would be bound to disclose material which undermined his status as an expert witness, wouldn't they?
That was a matter for the criminal lawyers to advise on.
No, Mr. Parsons, you're a lawyer. You were heavily involved, and we'll see how heavily you were involved when I ask you further questions about this in the instruction of Mr. Altman. And you had a brain. I put it to you again. In a case where the Post Office has relied on Mr. Jenkins as to the efficacy of the Horizon system, they were bound to disclose material to Mrs. Misra which undermined his status as an expert witness.
That's what I understand the position to be from the criminal lawyers.
Yet there is no mention at all in the minutes, no mention at all of that being discussed. Do you find that odd?
Yes, I do find that odd, given that that was probably one of the key issues that was under review at that point in time.
Yes. Now, I want to come, please, to a document that you sent under cover of an email, which we don't need to get up, but just for the sake of the record, it's POL 000219991, and you sent it to Mr. David Oliver and Mr. Chris Ojard, and it was in connection with Linklaters being approached. And the document that I want to put up is POL 00006484. You're familiar with this document?
I'm aware of it.
And you were aware of it enough to forward it to David Oliver and Chris Ojard when they were considering the appointment of Linklaters. And I suggest that this shows what was really in the background all the time, which dictated the actions that you and others, Mr. Parsons, because it's not just you, that you and others took. So I want to go to the second bullet point. It is reported that leading counsel, Mr. Morgan, said the proposal to instruct an independent expert to prepare a report on the Horizon system is the highest risk response to the issue. What will it achieve? It will not be able to address any of the civil criminal cases dealt with under old Horizon, so that would be legacy Horizon. Will it seek to review particular cases? If so, which ones? So immediately there, there is identified the problem of pre-2010 cases. Do you agree?
Correct. Yes.
Next bullet point. Whatever the findings of the expert report, it will not resolve the problem. The Post Office will be damned if they do and damned if they don't. If the findings are that there are no issues with Horizon, people will see that as a whitewash, whereas if the findings are negative, that will open the floodgates to damages claims by SPMs who were imprisoned for false accounting, and Access Legal will start to pursue all the civil cases they are currently sitting on. Now, can you just help us, please? Who were Access Legal? Were they a funder?
No, I think they were shoesmiths by another name, weren't they?
I'm very grateful, sir. Thank you. So, shoesmiths, part of which shoesmiths was one firm, part of a conglomerate of solicitors' firms, a network of solicitors' firms. Is that right?
That's my recollection, yes.
Right. So if the findings are that there are no issues with Horizon, it's a whitewash, whereas if they're negative, floodgates. And that was a matter as well that you were aware of, that there was a dam. And behind that dam, there were hundreds and hundreds and hundreds, perhaps, in fact, thousands of sub-postmasters who were the victim of unjust claims for compensation by the Post Office in respect of fictitious losses, and a lesser number, but still in their hundreds, of people who had either been convicted or had been, through force of circumstance, forced to plead guilty to, as the example is given there, false accounting.
So just as a point of context, this note is from June 2012. I didn't become involved until nearly a year later. I don't recall when this note was first provided to me. As to your question, I think it was always known by people at Post Office and the legal team that if Horizon was found to be fundamentally flawed, that would lead to a large and wide range of legal liabilities.
So whether you actually had personal knowledge of this note or not, it reflects, nevertheless, what would have been the concerns of the Post Office and also the concerns of Gavin Matthews, who was handling the Post Office account.
I think it's a almost natural consequence. If the IT system was found to be fundamentally flawed, there would be a wide range of legal liabilities.
Yeah, and that's why I suggest you are part of the policy of keeping it all at bay. To put it in a nutshell, delay, deny, get rid of the judge if you have to, but keep it all at bay. That was part of the policy that you signed up to at Bond Dickinson.
I don't accept that. When I began in 2013, the instructions I had is that Post Office believed the system was reliable. Second Sight had just concluded their interim review and found that there was no systemic problem. The basis on which we operated was that understanding. That understanding is obviously wrong, but it wasn't understood to be wrong at the time.
Now, do you remember when I asked you to consider your mindset when you went to that consultation on the 9th of September 2013 about whether you had concerns about floodgates and civil claims if criminal prosecutions were undone? And you said it wasn't operating in your mind at the time. There's no need to get it up, but you do remember that not that long after that, on the 8th of October 2013, you made a presentation to the Sparrow Working Group, didn't you?
I may have done.
Well,
help me with
you were taken to it yesterday. If need be, if you would like to see it again, we'll get it up on the screen. It's POL 000 22002. And it's page 14 of that document. Mr. Blake took you to it, and it was, and I think it's page 14. I do hope I'm right about that. Yes, there it is. Horizon inaccurately records data, transactions, recommendations, threshold of proof before offering a remedy. Very clear proof of technical defect in Horizon. Risks. The Post Office should be slow to concede that Horizon has any technical faults. I thought you were saying they thought it was robust.
They believed at that time it was a reliable system. It had obviously at that point in time already disclosed the 3 known bugs at that point in time. As I accepted yesterday, I think the bar that is set there on reflection is now too high.
But look what you say. To do so could open up the floodgates to a large number of claims. They must have been within your knowledge. You must have known that they were behind the dam.
As I said before, if it was always known to me, and I suspect others at Post Office, that if there was found to be a fundamental problem in Horizon that affected a large number of sub-postmasters, then that would open them up to a large number of claims.
And then, of course, it would be, you put it in terms like this, it will be almost impossible to reverse this position if conceded. I'm going to use the term domino effect. If the pin comes out of the grenade, then you can't predict where the shrapnel is going to end up.
The concern at this time was that there was some underlying fault in Horizon that was causing a wide range of losses that could explain the sub-postmaster's concerns. Now, we had no evidence of that at the time, and that's what we were concerned to understand, and that's what that's a reference to.
Did you like Second Sight?
On a personal level, yes.
Just help me with this, because it may be that I've got the wrong end of the stick, but could we go to POL 0002 1686? And could we scroll down? I think it is. I always say scroll up, but if we could scroll down. We've got 15th of February 2016, you to Mr. Burke, Mr. Underwood, Roderick Williams, copy Daniel Fawcett. Patrick, Mark, Roderick, for your information below, Dan found this in the SS emails. It looks like Second Sight feeding questions to Alan for use with MPs. Who was... Then if we scroll up, we can see that Mr. Fawcett has got access. Scroll down, I do apologise. We can see that Mr. Fawcett has got access to, for example, emails from Chris Hollyoake to Ian Henderson, Ron Warmington. Who is Daniel Fawcett?
He's one of the lawyers at Womble Bond Dickinson.
And was he junior to you or of the same? You were a managing associate at the time, I think.
Scroll up, please, so I can see the date. I would have still been a managing associate then. I think I was made up to partner on the 1st of May 2016.
So how did you get hold of these Second Sight emails?
At the end of the mediation scheme, Second Sight was asked to return all its emails to Post Office for safekeeping.
Was there any confidentiality implied in the return? In other words, that they were, returned, but nevertheless remain confidential?
I don't recall any.
Right. So this is after they've left the scheme. What were you trying to do? Accumulate dirt on them?
No, it was just an observation I'd made to others at Post Office. As I explained yesterday, one of the concerns I had about Second Sight is I felt that they were leaning too much in favour of the sub-postmasters and had lost some of their neutrality. I think I probably forwarded it because that email seems to be evidence of that point.
Right. And who instructed you to do this? I say you, of course it was done by Mr. Fawcett, but you're forwarding his product. Who was instructing you to do this?
Sorry, to review Second Sight's emails?
Yes.
I can't recall the context here. I'm just looking at the subject line, which says Poll DSARS SS Docs. If I remember, there was a period around 2015, 2016, where Post Office received a lot of data subject access requests from postmasters. So it may have been they were being reviewed in that context.
Right, well, let's go, please, now to POL 00413924924. And we can see that the heading is Second Sight Disclosure of Information to the Post Office on Prosecutions. Mr. Jarnal Singh forwards it. Could we scroll down, please? And could we scroll further down, please? Yes, there we are. Andy, this was a formal request and needs to be dealt with formally by Second Sight. As Mr. Altman advised, it can then be reconsidered. If then Second Sight still feel uncomfortable dealing with our request for disclosure, we may ask them to provide a witness statement to clarify their position on disclosure. So this is trying to obtain information from Second Sight, is it?
I believe the context to this is that at a working group meeting, I think it was, Second Sight had indicated that they believed they had evidence that was relevant to prosecutions.
Yes. Can we just scroll up, please, or scroll down? We want to go to the next one. Yes. And then there is an email from you. If we could keep on scrolling down, please. Further, please. So sorry, I'm not finding the part. There is an email where you say that you gently warned Mr. Ron Warmington. So if we could just go and see that. It's in the body of this email. It's page 2. Yes, thank you so much. It's the third, it's the penultimate paragraph. Ron is going to write a response to Post Office along the above lines. I have gently warned Ron Warmington that he needs to be careful about anything he says in relation to criminal prosecutions, as such comments are under heavy scrutiny and have consequences. He is now more comfortable with how to handle the situation. Hopefully the Second Sight letter will close down the issue. Can you help, please? Who was heavily scrutinising Mr. Warmington's comments about criminal prosecutions?
I don't think it was specifically aimed at Mr. Warmington's clients.
Well, then why did you gently warn him?
So my recollection, and it is rather dim now, is that Mr. Warmington had said at a meeting that he had material that he thought was relevant to prosecutions. That had caused Post Office to respond to that and discuss whether they then needed to get access to that information, what were they going to do with the information if he did have it, etc., etc. But the output of this actually is Mr. Warmington accepted he didn't have such information, or at least he didn't have any new information. And so the point of the conversation with Ron was that to say to him, he needs to be careful with what he says because he'll set hairs running on these points, which causes a lot of work to be done, in this case, actually for no purpose at all.
Why didn't you say that? Why have you said instead, I gently warned him that he needs to be careful about anything he says in relation to criminal prosecutions, as such comments are under heavy scrutiny and will have consequences?
I've given you my explanation for it, which is if comments are made by people at this time that they believe they had material relevant to prosecutions, that was something Post Office was alive to and they needed to do something about.
At its most anodyne, this was an attempt to steer Second Sight away from their interest in criminal cases, the investigation of criminal cases, and the prosecution of criminal cases, wasn't it?
No, it wasn't.
At its worst, it has all of the appearances of a threat.
No, it wasn't. I don't believe it was, and I believe there is a letter actually from Second Sight at the end of this somewhere.
Was this an attempt to close the lid on potential criminal appeals that might be caused by, to use the expression, careless lips cost ships, or, you know, blurting out something which might then be used by a prospective criminal appellant?
Not at all. In fact, I think it's the opposite. I think Post Office heard something in a meeting and acted diligently to figure out whether that was something of substance.
Well, what about the hare that you said this could set running?
In terms of work being done in this case for no purpose, because actually I believe the output is that Ron decided he didn't actually have any material.
We saw that you're quite good at closing things down. I mean, for example, no need to take you to it, but Mr. Blake took you yesterday to what you described as high-level advice, which shut down the lessons learned review, or if it didn't shut it down, it diluted the lessons learned review because you were concerned about proactive disclosure in criminal cases. You remember that? You were taken to it.
I remember the document, but
Yes.
I think it's important to remember that the instruction we had was to point out the risks. We weren't asked to give an opinion on whether it should go forward, hence why my email contains a series of negative statements and risks.
And you also, I suggest, were quite astute in positioning Mr. Altman so he did not feel it incumbent upon himself to point out a flagrant miscarriage of justice.
I don't recall any such conversation with Mr. Altman, and as I tried to explain yesterday, I don't believe I had substantial involvement in Mr. Altman's terms of reference.
Well, we saw yesterday, of course, Mr. Matthews saying that Mr. Altman should not opine on safety, but wasn't there also a debate as to whether his advice should be private or public?
I recall that as a topic that was discussed.
And wasn't there also some fudging about the fact that although he was being instructed by Bond Dickinson, there was toing and froing as to establishing his terms of reference? The ambit of his instructions.
I recall there was a terms of reference and there was some discussion about them, but as I explained yesterday, I don't believe I had substantial involvement in them.
Well, I want to go, please, to POL 00297-951. And this is you to Mr. Roderick Williams, copied to Mr. Matthews regarding Mr. Altman. Brian looks like the right man for the job. In my view, he was very impressive. He's clearly undertaken this type of exercise before and is very live to the political dimension, which was?
At that time, Post Office was under pressure from a group of MPs following the publication of the Second Sight Review.
And the Post Office must not fail.
I don't recognise that comment.
Big question, is Brian's work private advice for the Post Office or an independent assessment of the Post Office's criminal law position? One for us all to think about. they're your partner. When I say your partner, the partner above you, because you hadn't yet been made a partner, had you?
No, not at this time.
No. The partner above you is being copied. Then you say short term, Brian is going to assist with the response to the CCRC. Would that be the holding response?
I can't recall now where we were in the
It must have been the holding response, mustn't it?
It may well have been, but as I say, I can't recall the exact sequence of letters.
Longer term, we need to draw up some terms of reference for his work. Gavin and I will have a first stab at this and then circulate this to the team. And then, could I ask you, please, could we go to POL 002981123? And could we go to page 2? This is, of course, signed off by Gavin Matthews. Our advice is the Post Office Legal needs to disclose Brian Altman's interim review to Cartwright King and discuss it with them. Cartwright King should be asked to respond in writing to the recommendations made at paragraph 24 and paragraph 15. And then this, Bond Dickinson, that's you, should sit down with Brian Altman to walk him through the spot review process and the second sight report so that he can understand the impact of his review on the civil side. Help us about that, Mr. Parsons. What does that mean?
I think Brian wanted to understand more about the second sight report and the spot review process. I don't understand the comment at the end about the impact of his review on the civil side.
You don't understand that comment?
I can understand that if any of the convictions were found to be unsafe and overturned, it would have civil liabilities for Post Office, but I don't know what Gavin had specifically in mind with that comment.
It's all about the dam again, isn't it?
As I've accepted, my view at the time, and I believe others at the time, accepted that if Horizon was to be found to be fundamentally flawed, it would give rise to potential legal liabilities.
Would only take one successful criminal appeal where there was proper, candid disclosure in accordance with the law, and the whole dam would collapse, wouldn't it?
I don't recall thinking about things that way at the time.
But you don't understand, you say that Mr. Altman can understand the impact of his review on the civil side. You tell the chairman that you don't understand what on the civil side means.
No, I think I've tried to explain that I understood that if a conviction was found to be unsafe, it would give rise to civil liabilities. That's my general understanding of the interrelation of those, of the criminal side and the civil side. What I said is I didn't understand what specifically Mr. Matthews had in mind when he drafted that sentence.
Right. I want to try and deal, please, with one, if the shorthand writer can cope with another 10 minutes. I'm very grateful, sir.
Well, hang on, Mr. Henry. When you say another 10 minutes, does that mean you'll finish?
No, sir, because I think I started at 11:20.
Yeah, sure. I think it was a little earlier, but never mind. I think I'd prefer to take a break if you don't mind.
Certainly, sir. Certainly.
And we will start again at 12:05, and then you can keep going, so to speak, until about 20 to 1, quarter to 1.
That's very kind of you, sir. Thank you.
Ready when you are, Mr. Henry.
Thank you, sir. Mr. Parsons, solicitors have a fundamental duty to act in a way that upholds justice, do they not?
Alongside a series of other ethical duties, correct.
You don't suggest by saying that that fundamental principle is, as it were, subject or dependent upon the other principles. Let's reflect upon it. Solicitors have a fundamental duty to act in a way that upholds justice, yes or no?
It is one of the duties. There are other duties as well. I don't think those duties necessarily need to be incompatible with one another.
Right. Now, just help me, please. Who was giving the advice in relation to the redaction of Gareth Jenkins' name? Do you say that that was not your responsibility?
Are you talking about the Helen Rose report?
Yes.
No, I don't believe it was my responsibility. It was redacted by Cartwright King.
Anybody else?
Not as far as I'm aware.
I mean, did you ever gather anything at all from Mr. Altman about what should be done with Mrs. Misra?
I don't recall Brian advising on anything specifically with Mrs. Misra, but that may just simply be because of so much time has passed, I can't recall it.
Well, we know that he was advising on the 9th of September 2013 that she should not be involved in the mediation process. And the reason for that was that it might give her a ground of appeal, was it not?
I recall the criminal lawyers, both Cartwright King and Brian, both voiced objections to sub-postmasters with convictions participating in the scheme.
I'm talking about the actual name of Mrs. Misra being raised in that specific context, not just convicted people, but Mrs. Misra herself. It's in the note.
It may be, I don't have it in front of me. I'm just saying I can't recall that now.
But you do recall well, you've already agreed with Mr. Blake. I won't need to go further. What happens if a criminal lawyer is giving advice which you don't understand or which you consider to be wrong? That would surely put you under a duty to do something about it, wouldn't it?
If I had such awareness, I would, yes.
You've already confirmed that you did have such an awareness because you don't dissent from the proposition I put to you that if the Post Office relied on Gareth Jenkins as a witness to convict any particular person, they would be bound to disclose material which undermined his status as an expert witness.
That was my understanding from the criminal lawyers, yes.
Right. Okay. Well, I want to now deal with Mrs. Misra particularly, and could we go to WBON 0000, so 4 zeros, please, 746. And this is you to Mr. Williams and Mr. Pheasant and also to Mr. Matthews. I think I've pinned down what happened with Misra. This was a criminal case. We subsequently reviewed the transcripts of the criminal proceedings to identify anything relevant to Horizon. Attaches a memo, key findings, 3 tables with detailed cross-references to the Misra court transcripts identifying all the relevant material. I omit words. Having reviewed these documents, I can't see anything that looks like the 1462 or Falkirk bug. However, it does appear that the Misra case went through Horizon in detail. Could we now turn, please, to, well, insofar as you can, by the 1st of July, you got up to speed with Mrs. Misra's case?
No, I think this work was undertaken by an associate in the team, and it was undertaken to specifically look for references to bugs, and so it had a very narrow remit as per the instruction we had from.
But look at the materials referred to, a memo of the key findings, 3 tables with detailed cross-references, etc., etc. I mean, you said at the outset, I think I pinned down what happened with MISRA.
Yes, based on those documents, I would have read them at the time to identify the question we were being asked, which is, was there any references to bugs? I do note, and just want to correct, it says there, I can't see anything that looks like the Falkirk bug. I think the Falkirk bug was referred to in MISRA, and that was a mistake.
Quite right. POL 00111-625, please. Can we make the bottom left-hand corner, if we focus on the bottom left-hand corner, you drafted this, didn't you?
This document was provided to me at the start of today, so I've not had a chance to look into it, though I note the bottom left-hand corner has a reference that looks like my firm's reference.
Yes.
But the rest of the document isn't in my firm's house style, so I can't now recall the provenance of the document.
It's got a 4A reference, which is exactly the same reference that was put on the Horizon Risks document, which at one point you thought had gone to the board and served the dual purpose of advising the board and also notifying the insurers. So that's your firm's reference, isn't it?
It looks like my firm's reference.
Right. So can we just go to page 2 of this document, please? Paragraph 8. In brackets, we believe James Arbuthnot may feel that any interim findings which disclose any issue with Horizon should result in past criminal prosecutions by Post Office Limited being reopened and overturned. Paragraph 19 on page 4, please. You're dealing with the 2 anomalies there, the 62 branch, paragraph 20, page 5, the 14 branch, and then could we deal with paragraphs 30 to 32, please, on page 6. Now, the Falkirk anomaly was the subject of expert evidence in the MISRA criminal prosecution, where the defence expert asserted that its existence demonstrated Horizon had faults which could cause losses, and therefore that possibility could not be excluded in MISRA's case. The prosecution expert, Gareth Jenkins from Fujitsu, asserted that it could not have been responsible for the losses because its clearly visible events had not manifested themselves in the branch records, and that it had been fixed more than a year earlier. MISRA pleaded guilty to false accounting and was convicted by a jury of theft. To reach this verdict, the jury had to be satisfied that the charges were proved beyond all reasonable doubt. She was sentenced to 15 months imprisonment. There has been no appeal against the conviction. And of course, anybody reading that and anybody preparing that document would realise that in order for her to be convicted on theft, the jury would have had to have been satisfied, as it says, beyond all reasonable doubt. And who was the prosecution expert? Gareth Jenkins. Now, you were aware, as you've already said today from paragraph 87 of your witness statement, of the Gareth Jenkins problem from the 8th of July, and you received the clerk advice on the 17th of July 2013 from Susan Crichton. You read this document, didn't you? Did you prepare it, or were you part and parcel of preparing it?
As I say, I haven't had a chance to investigate it because I was only provided a copy this morning. It's got our reference on it, which means it probably was sent to us at some point in time, at least. I can't now recall what input I may have had into it or not.
Could investigations be made into who was the author of that document? Is that what you're saying?
It might be possible.
Right. Well, Mr. Parsons, Mrs. Seema Misra and her lawyers should have been provided with information of Gareth Jenkins' misfeasance as soon as possible after that misfeasance came to light, shouldn't they?
Looking back on it now, that would be my view, but at the time that was being advised on by Cartwright King and Brian Altman, and I followed their advice.
What about your fundamental duty to act in a way that upholds justice?
At that time, I wasn't aware that there was any problem with what the choices the criminal lawyers had made.
Can we just focus upon that? Because, of course, you've read the Clark advice. You are alerted to the problem at least a week before, slightly more than a week before you read the Clark advice. Mr. Jenkins, an unreliable witness, correct?
Correct.
Post Office could no longer call him because his credibility was shot, correct?
Correct.
Failed in his duties to the court.
That was the advice from the criminal lawyers.
Said to have given false or misleading evidence in the cases in which he was involved.
Again, that's from the advice from the criminal lawyers.
And you knew he had given oral evidence against Mrs. Misra.
I did.
Isn't it obvious that the substance of the Clark advice, the facts which were not cloaked in privilege, should have been stated clearly to the CCRC in the holding letter you drafted?
At that time, I was just drafting a holding letter whilst Post Office sought advice from their criminal lawyers.
Seems, however, in that holding letter that the Post Office is trading on Brian Altman, all in the context of the Second Sight interim review. But the tainted witness, the unsafe witness that gave evidence against Seema Misra, isn't mentioned in that CCRC letter at all.
I haven't got it in front of me, but I don't recall that he was mentioned in it.
You accept, don't you? It's not mentioned at all.
I think that's right. Yeah.
I mean, that letter is indefensible because of that omission, isn't it? Gives false reassurance to the CCRC.
At that time, it was just intended as a holding letter with an intention that further correspondence would follow about these issues.
The omissions, and I no need to repeat them, you've accepted what they are. The omissions are indefensible, aren't they?
Which omission are you referring to, Mr.
Well, that Gareth Jenkins was in breach of his duty to the court. That, oh, by the way, we know he gave evidence orally and in writing in numerous cases, which is said to be misleading, and he hasn't acted in accordance with his obligations mandated by law and the criminal procedure rules, Rule 19. Instead, we've appointed Brian Altman in relation to the Second Sight interim review, and you continue to trade off Brian Altman's reputation going forward as well, don't you?
No, that isn't how I recall the events. My recollection is that Post Office was seriously concerned about the Clark advice and Gareth Jenkins' past testimony. That is why they instructed Brian Altman to give them a view that they were doing the right things in response to that situation.
They were seriously concerned because the facts that are dealt with in the Clark advice, and the Clark advice itself, is the pin in the grenade. And they wanted to keep the pin in the grenade rather than the grenade going off. That's the truth, isn't it?
Not that I can recall at that time, but I wasn't cited on the decisions that were made on who should get what disclosure and what disclosure should be given.
Well, you actually are concerned sometimes in cases, and you actually query Mr. Clark, we'll come to it if necessary, and say, well, shouldn't this be given?
I saw that as the role of Cartwright King under the supervision of Brian Altman.
Right. Advice is given, and you give this advice, that the report, that's Mr. Altman's general review, gives good grounds to resist any formal external review of the Post Office's historic prosecutions, i.e. by the CCRC. That document is POL 001 23004. I don't need to take you to it. But no one is mentioning Seema Misra, are they?
Do you mean in that particular document?
Yes.
I don't recall her being mentioned in that document.
No. Again, an indefensible position. The advice is given that the report gives good grounds to resist any formal external review, yet all of that rottenness, all of that taint in relation to the architect of the system and the expert that the Post Office had used is airbrushed from the picture. It's deliberate, isn't it?
No, not as far as I can recall. My understanding was that Post Office thought that if Cartwright King were to make the correct disclosures in the cases having undertaken their review, and that Brian Altman had reviewed that process and agreed that it was a sound process, and that information was provided to the CCRC. The CCRC may then decide that they don't need to undertake their own investigation. And of course, Brian Altman's advice was provided to the CCRC, admittedly later, but at the beginning of 2015.
What you're getting, in fact, is layer upon layer of external lawyers giving the vestige of respectability, but at the heart of it, buried underneath all of this, is the fact that an obvious disclosure decision to disclose to Mrs. Misra's lawyers is never taken so far as Gareth Jenkins' misfeasance.
That appears to have been the case, but as I say, I wasn't involved in that decision at that time.
Now, I want to come very briefly to the comparison of your Horizon Risks document and the document that Mr. Roderick Williams was involved in. And if we can get up your document, which is POL 0002 1996. And if we could go to the prosecution risks chapter or section, please, the second page. Prosecutions and convictions. And we'll take it as read that that second paragraph in particular, the expert evidence, Dr. Gareth Jenkins of Fujitsu, and we can see that there is in the last sentence, may have undermined a prosecution case or assisted with an accused defence. Forgive me, sir, I'm just looking at a reference. Right. Do you see that even you have put a prosecution case, may have undermined a prosecution case?
Yes, I can see those words.
Singular. That's a reference to Seema Misra, isn't it?
I don't believe so. I think you're reading it differently to the way I'm reading it. I don't think I'm reading that as there has been a single prosecution case, as opposed to it could undermine a prosecution case, as in there could be many of them, but it might undermine them.
But he did give evidence orally in any one case. But let's contrast that, because the contrast is even more pronounced if we go to POL 000 40026. And this is the draft which you said was, I think, unacceptable because it was apparently misleading. And could we go to the same section, prosecution, please? Yes. And there, prosecution and conviction, second paragraph, Post Office has an obligation to consider whether further discourse, which should be disclosure, should be made to defendants. It is of concern to Post Office that the expert evidence of one prosecution witness, Dr. Gareth Jenkins of Fujitsu, may have failed to disclose certain problems in the Horizon system potentially relevant to a case. There can be no doubt there. That is singular, and that is referring, is it not, to Seema Misra?
It definitely seems to be singular. I don't know what it was referring to, because I think it appears that those amendments were made by either Roderick Williams or Cartwright King.
Yes, and that's clear because it has been done, and there's no need for me to take you to it, but I'll give the reference for the transcript. POL 000400026. Forgive me, POL 000400025. That was done after amendments by Roderick Williams and Cartwright King. But paradoxically, although it would have appeared to have been misleading, it made it clearer that that one case must refer to the only case in which Mr. Jenkins gave oral evidence, the case of Seema Misra.
It seems a fair possibility, but I don't know for certain.
It does. Now, Cartwright King, clearly an appeal is on the cards because the amendment is the 26th of August 2013. That's the email back to you which says this has been done with amendments by me and Cartwright King. So that suggests that there may be an appeal in the offing, hence the disclosure to the insurers. 5th of October, there's a document drafted by Cartwright King that she was due to receive disclosure, Mrs. Misra, that disclosure ought to be given to her. But then we have to fast forward to January 2014, and a decision is made that she isn't to get disclosure. Do you have anything to say about that?
I was unaware as to the decisions made in relation to individual cases as to who got disclosure, who didn't.
I suggest that the 21st of October could be a key date in understanding this. No need to get it up on screen, but you were taken to it yesterday, and counsel to the inquiry, Mr. Blake, linked two documents. One was POL 003-72551, which was Miss Venables to Alice Perkins, talking about the unsafe witness. And then there's another one, you, writing to Andy Holt, Gavin Matthews, Belinda Cortes Martin, and Jarnal Singh, and it's POL 00123-004. And perhaps we should get that up on the screen, please. Could we scroll up, please? And scroll up, please. This is from you. And scroll up, please. And scroll up, scroll down, sorry. And scroll up. Yes. Brian Altman's first review has now been received. Again, no mention. It's the same day as Miss Venables talks about the unsafe witness, but no mention at all by you of the Gareth Jenkins problem. Is there?
No. At that time, I presume that everybody receiving this would have been aware of the Gareth Jenkins problem because it had been raised some months before.
But it's always a sensible idea in considering this whole issue about whether there are good grounds to resist any formal external review of its historic prosecutions, to mention one thing which eminently qualifies for investigation and review by the CCRC, which would be the Clark advice.
As I said, I assume that the recipients of this would have all have been cited on the original issue that was raised in the Clark advice.
Now, you're familiar with the issues. You've already given evidence about them. But if Mrs. Misra had had prompt disclosure, she would have had an unstoppable appeal, and her appeal would have exploded not only Mr. Jenkins, but also the Post Office's management of Mr. Jenkins, wouldn't it?
I can't comment on how her appeal may have gone, but it seems to me that she would have had grounds to appeal, and that would have had, and had she been successful in that appeal, it would have had serious knock-on consequences for Post Office.
And we take the terms of the inquiry, of course, by reference to the Horizon Common Issues, the Horizon Issues, and also the Hamilton Appeals. But it would have also blown up remote access because of material non-disclosure of documents known to the Post Office in 2010 in relation to remote access and insertions of data to resolve the receipts and payments mismatch bug, which ought to have been disclosed to her as well. So it would have been catastrophic for the Post Office, wouldn't it?
An appeal, a successful appeal against a conviction on the grounds that Horizon was not a reliable system would have been seriously damaging for Post Office.
And in fact, the very document that caused Mr. Justice Fraser so much concern, a Fujitsu document which talked about the receipts and mismatch bug and the insertion of data, solution 1, solution 2, solution 3, which ought to have been disclosed in Mrs. Misra's trial. I mean, it would have made it incredibly difficult to defend the Horizon Issues trial, wouldn't it, as well?
If we're thinking about the same document, I understood that document had been provided to Second Sight. I believe if we're talking about the same document, so the document was out there with them to investigate at the time. And yes, if it's the document I'm thinking about, then it was referred to in the Horizon trial.
So what I'm going to suggest instead, this is my last topic, and I've got a quarter of an hour, is that instead a rationale for limited disclosure was devised, namely the provision of the Helen Rose report, because it potentially revealed Mr. Jenkins to be unreliable based on his knowledge of system errors, which he did not reveal. And you knew that, of course, because you'd read the Altman General Review, hadn't you?
I was aware of the problems with Gareth Jenkins' evidence.
Yeah, and I'm going to give the reference, no need to take you to it, but it's POL 000, so 4 zeros, forgive me, 4 zeros, 6803 at page 54, because in the Altman General Review, there is a reference to that and how the Helen Rose report might have a potential for an impact on Gareth Jenkins' credibility. Now, in paragraph 183 of your statement, you relate a conversation you had with Mr. Simon Clark. Whether the conversation was oral or in writing, I don't think is clear, but paragraph 183 of your statement at page 110, I'm just going to quote the last sentence. He, that's Mr. Clark, explained that the reason for disclosing the Helen Rose report was its potential to impugn Gareth Jenkins' credibility as a witness, and the appendix did not speak to that issue. Do you remember that?
Yes.
So can I now come, please, to POL 000-29707. And this you'll remember is an email that you write to Belinda Crowe, Belinda Cortes Martin as is now. And could we scroll up to a paragraph which has contained within it? Yes. See that paragraph just for background information. The material part of the Helen Rose report has nothing to do with her comments about reversal data. And then I omit words. The concern was not with the data's accuracy, but that the presentation of the data could be misleading if its limitation were not fully understood. Putting this issue aside, the real and confidential reason that the report was disclosed was because Helen's comment at the bottom of page 3 suggests that it was widely known that there were problems with Horizon. This statement, regardless of whether it's correct, could have been used to attack Gareth Jenkins' credibility as a Horizon expert, as he had previously stated that there were no problems with Horizon. Now, I've already referred you back to the general review by Mr. Altman, where he said at the page reference I've given, quotation, "The Helen Rose report adds very little, or at least so it seemed to him, other than to point to a particular issue at Lepton, and the implication from the report is that as early February 2013, Gareth Jenkins was aware of integrity issues with Horizon, none of which he revealed." Can I ask you this? Did Mr. Altman tell you that the real and confidential reason for disclosure was that it might permit an elliptical attack on Gareth Jenkins' credibility?
I can't recall if it was Brian Altman that had told me that, but I understood that was the concern with the Helen Rose report.
And that concern was a concern that was shared. It's obvious because Mr. Altman has written what he's written, but it's a concern, you say, that is shared among the criminal lawyers.
Yes.
Right. So, in other words, the widely known problems with Horizon could therefore be used to attack his credibility because he'd stated previously, Mr. Jenkins, that there were none. Correct?
Yes, as I described there, page 3 suggests there were widely known problems.
Now, Simon Clark, Mr. Clark, based on your statement, he thought that credibility was the real reason to disclose, didn't he?
I believe that's the case.
You checked it with him the day after your email of the 8th of April, on the 9th of April. You footnoted, in fact, you footnote 127 and 128 of paragraph 183. They are your email to him about it and his email to you.
Yeah, I recall around this time I spoke to Simon about these issues and the redactions that have been made in the Gareth Jenkins document.
Right. So I want to go now to one of the documents that you refer to in footnotes, which is WBON 0000, so that's 4 zeros, 834. This is what he's saying to you. This is the first I've seen of an appendix, so it did not go out with a disclosure pack. Nevertheless, my opinion and advice is unchanged. This was a data presentation issue, not a Horizon failure. See last question and answer and recommendation in the main report. Thus, the disclosure issue remains that relating to the credibility of Gareth Jenkins as a witness only. I do not see that the appendix is disclosable in the criminal arena. It adds nothing to the credibility issue of Gareth Jenkins and cannot therefore meet the test for disclosure. Hope that helps, or hope this helps. So it follows from that, out of his own mouth, that Mr. Clark knew the reason to disclose was that it revealed the Gareth Jenkins credibility issue.
Correct.
Not just the problems with Horizon that need to be disclosed about bugs, but also Mr. Jenkins' knowledge of them and his failure to reveal them before or during trials. In other words, the classic unsafe witness point.
Correct. There was a credibility issue with Gareth Jenkins' evidence.
Right. And it seems that Mr. Altman appreciated the same point, given what I've taken you to from his general review.
Agreed.
But it seems, and you, of course, as an intelligent observer, apprised of the issues, it seemed that neither of them were going the whole hog, as it were. Neither were following the logic inevitably demanded, that character and credit is indivisible, and Mr. Jenkins' failure to disclose the existence of bugs was inseparable from his failure to act in accordance with his duties as an expert. You must have realised this.
I was aware of those issues, yes.
And did it not strike you as extraordinary that these two experienced criminal lawyers were, as it were, dancing around the elephant in the room?
It didn't at the time, no.
Is that it, Mr. Henry?
I think that is it, sir.
Thank you. Ms. Dobbin.
Thank you, sir. Mr. Parsons, can you see me?
Yes, I can.
I represent Gareth Jenkins. My name is Claire Dobbin. I wanted to ask you about two things, if I may. And the first thing is something, in fact, that my learned friend Mr. Henry has already touched upon. So I'm not going to go back to this document, but you'll recollect at the outset he took you to an email of the 1st of July 2013 that you wrote. Do you recollect that?
No, I'm afraid. Would we mind putting it up? Sorry.
Of course I will. It's WBON000746.
Thank you.
So I think we can see, can't we, from this email, Mr. Parsons, that some work had been undertaken, and by your firm, I think they had prepared some notes of the trial of Mrs. Seema Misra. Is that correct?
Yes, but specifically targeting one question, which is whether there was something in the transcripts that referred to specific bugs in Horizon.
Yes. And you had reviewed those notes, and as you've said out there, you couldn't see anything that looked like the 14 bug, the 62 bug, or the Falkirk bug, correct?
That's what it says there, but as I accepted earlier, that was wrong, because I think it does refer to the Falkirk bug.
Quite so. In fact, Mr. Jenkins answered a number of questions, didn't he, about the Calendar Square bug?
I can't recall now. I haven't looked at those memos for a long time.
All right, but have you actually been through the transcripts of the Misra trial?
No, I've only read the memo that was provided by my team.
So, to be clear about this email of the 1st of July is based upon a misreading of the memos that were prepared for you, is that right?
Correct.
And you have never gone back and examined the transcripts of the trial of Mrs. Seema Misra?
I don't believe I've ever read the transcripts of Seema Misra's trial.
Well, Mr. Parsons, I won't ask you any questions then about those transcripts. But then just in terms of the other bugs, I think it's right, isn't it? The 14 bug, I think you probably now know after the civil proceedings, that's a bug that came to light at a later point, correct? The suspense account bug.
Yes, this would have been after, this was around 2011, 2012, I think.
Yes, and I think came to Fujitsu's notice in 2013. Do you recollect that?
That's my understanding.
And I just wanted to ask you about this 62 bug, which Mr. Henry has also touched upon. And I wanted to ask you this. At the time you were speaking to Post Office about this, did anyone mention to you or explain that Mr. Wilson, one of the prosecutors at Post Office, had in fact made a decision that notes relating to that bug shouldn't be disclosed to Mrs. Misra at her trial?
I don't believe anybody told me that.
And did you ever speak at all, again, when you were doing this work for Post Office and asking questions or trying to ascertain what had been known at this time, did you ever speak to Mr. Singh about what he knew, given the role, or given that he was the prosecutor, in fact, in a number of cases?
I don't recall when I first spoke to Mr. Singh. It may have been after this. I don't recall asking Mr. Singh any questions about his state of knowledge.
Did he ever volunteer any information to you about what, in fact, Mr. Jenkins, or information Mr. Jenkins had provided to him in the course of Mrs. Seema Misra's trial? Proceedings?
I don't believe so.
Another question that I wanted to ask you related to this is that the inquiry has seen evidence that in and around September 2013, a lawyer from Cartwright King and a lawyer from the Post Office appeared to understand that there was a serious issue as to whether or not Mr. Jenkins had ever been instructed as an expert. Again, was that information that was ever brought to your attention at the time by them?
I only first heard of that issue in the course of this inquiry.
It appears that your firm had recommended the instruction of leading counsel in relation to the review of the prosecutions because there was the concern that there might be a conflict with Cartwright King. Is that correct?
I recall there being a concern over the conflict with Cartwright King.
And do you think then that it was, ought that information that they knew in 2013 that there was a serious issue as to whether or not Mr. Jenkins had been instructed as an expert, ought that information not have been brought to your attention, given the reason or the rationale for the instruction of leading counsel?
I think it's important to understand the nature of my firm's role.
Yes.
Which was to act, as I said yesterday, as a conduit to Brian Altman. The scope of information that Mr. Altman then needed to do his job was left to Mr. Altman to inform us, actually, as to what information he needed.
Yes, that's information. It would be difficult for Mr. Altman to know that information unless someone volunteered it to him, correct?
I guess so, though I wonder whether if Mr. Altman had asked certain questions, that information would have been brought to light.
All right. Mr. Parsons, this isn't a criticism of you. I'm just trying to understand, given your concerns or your firm's concerns about potential conflict related to Cartwright King's conduct of prosecutions and their understanding that there was a serious question as to whether Mr. Jenkins had been instructed as an expert. Again, whether you think that that is information that ought to have been brought to your attention at the time.
Looking back now, it seems like it's information that should have been, but I think I'm very cautious about the phrase "brought to my attention."
Yes.
Because, as I say, our role was to make sure the information was flowed through to Brian Altman, and for Brian to make requests for what information he needed.
Well, let me broaden it out then. It's right, isn't it, that is information that ought to have been brought to Mr. Altman's attention at that time?
It strikes me that would be useful information for Mr. Altman to have known.
Yes, it's useful because I think, to use Mr. Henry's turn of phrase, it would have opened up questions, wouldn't it, about Post Office's management, to use his term of Mr. Jenkins, correct?
Yes, I can see that line of
And
inquiry.
may indeed have opened up wider questions as to Post Office's ability to conduct prosecutions as well. Do you agree?
I'm not sure. I'm not sure I'm able to answer that second question
Sorry,
as to what Post Office might do with future prosecutions.
Sorry, that it was badly put by me. It might open up questions as to the competency with which Post Office had been prosecuting cases. Do you agree?
Yes, if Mr. Jenkins had been improperly instructed.
Yes. All right. I'm going to move on and ask you about a completely separate topic, if I may, and that's related to the civil proceedings. I'm not going to go back to your witness statement, Mr. Parsons, to cover this. I wanted to see it if I could just do it without having to do that. I think that you suggest that there was the concern about using Mr. Jenkins as a source of information in the civil proceedings, correct?
There was a concern about using him as a witness in the proceedings, and related to that, there was then doubts over the information that we were getting from Gareth Jenkins, but we still nevertheless spoke to him and saw his opinion on certain points.
All right, I wanted to ask you this. Can you point us to any communications, for example, emails or written correspondence with Fujitsu in which you set out any direction or instruction about the approach that they were to take to Mr. Jenkins, or the use that was to be made of Mr. Jenkins in providing information in the civil proceedings?
I can't recall any such email at the moment.
Was there such an email, Mr. Parsons?
Best of my recollection is no, but there was obviously a lot of correspondence around that time, so I couldn't state definitively.
Right, so is it the position, Mr. Parsons, that despite this concern or caution around using Mr. Jenkins, that was not, in fact, something that was communicated to Fujitsu?
It was. I don't believe it wasn't communicated by me to Fujitsu. I don't know if somebody else had communicated it from Post Office to Fujitsu, but I was operating on the understanding that Fujitsu were unaware of the concerns we had about Gareth Jenkins' evidence.
I was just looking at the transcript because I wanted to make sure I hadn't misheard you. Fujitsu were unaware of the concerns about Mr. Jenkins' evidence, is that correct?
I'm saying that was my understanding
Yes.
at the time.
And you are the key person, Mr. Parsons, aren't you, in terms of the conduct of the civil litigation?
Yes, I think that's fair, alongside leading counsel.
And it follows from all of that, doesn't it, Mr. Parsons, that Mr. Jenkins didn't know the position that he was being put in the civil litigation either?
I can't talk to Mr. Jenkins' state of knowledge.
Well, he didn't know, did he? Because you didn't communicate it to Fujitsu that he wasn't being used as a witness because of these historic concerns about the evidence that he had given previously, or the criticisms that had been made of him.
I think, as I say, I can't speak to Gareth Jenkins' knowledge, but as far as I was aware, he was not aware, if I can put it that way.
Can I just ask, how could you have let that situation arise, Mr. Parsons, whereby you were making use of someone as a source of information in the civil proceedings, and yet all the while not telling them that they had been subject to this previous criticism, and in fact that was the reason why they weren't being used as a witness?
So as I explained in my statement, it was a less than ideal situation. In fact, it was a very difficult situation. Our expectation until much later in the group litigation is that we wouldn't need to rely on Gareth Jenkins. We thought we'd be able to get the evidence from Torsten Godseth or some others at Fujitsu. I was aware there was always a concern that there would be points on which only Gareth may be able to give evidence, but until the issues in the litigation took shape, around the horizon issues that is, which only really took shape around, I think it was August 18, so quite deep into the litigation. The point around Gareth Jenkins' role and his role as a witness hadn't really taken hold until that point in time.
But do you see the position that you were putting him in, but without him knowing anything about the reality of his situation?
I think we were speaking to Gareth as a source of information, and given that we had decided not to call him as a witness, I didn't see there was a challenge with that.
But you didn't see that you were potentially exposing him or putting him in a difficult position by doing that? Given, for example, whenever witnesses said that they had spoken to him about something, whenever they came to give evidence, can you not see that that's putting someone in a difficult position?
I'm not sure what difficulties you are envisaging here. We were asking Gareth questions. He was, I'm sure, to the best of his ability, answering those questions. I don't see asking someone questions and getting answers puts them in a spot of difficulty.
You don't see a difficulty in using someone in litigation in making a decision not to call them as a witness, in deciding that you need to be very cautious and careful about how you're using them, and yet not tell that person that that's the position they're in. You don't see a problem with that? There's several difficulties, but they're mainly for Post Office to manage in the litigation process. But that idea did not cross my mind whilst we were in the litigation. Thank you, Mr. Parsons.
That it, Mr. Blake?
I believe that is, yes.
All right. Well, thank you very much, Mr. Parsons, for your very detailed witness statement and for answering questions posed to you by a number of people over a day and a half at this inquiry. I'm grateful to you. And so we'll stop now and adjourn until Tuesday morning, when we'll hear from Mr. Henderson, I believe.
That's correct, sir.
All right. Thank you all very much.
Thank you very much.